means nobody pays VAT. It's just reporting input and output VAT, which is very, I would say, stimulating for this kind of industries. From the corporate tax perspective, we talk about financing the projects. When we talk about tax aspect of financing the projects, from the corporate tax perspective, basically the Serbian legislation allows a 5-year carry forward of tax losses. So when you start investment, you make some, if it happens that any losses are incurred, they can be carried forward to offset future taxable profits in the 5 years. The 5 years carry forward of capital losses on capital transactions, and also one of the new announcements in the change of the corporate tax legislation, if it happens to be adopted by the parliament, by the Serbian parliament by the end of the year, is going to be the tax incentive for the research and development activities, meaning that if you have any kind of qualified, we still don't know what in practice is going to mean qualified or by definition research and development, that kind of expense will be recognized in the double amount for the tax deduction. That means you can decrease your corporate tax base for 200% of your research and development expenses. If you incur 1 million of these expenses, you can decrease corporate tax base for 2 million, which is quite good incentive. As I said, hopefully if it becomes adopted by the Serbian parliament, it is at the moment proposed by the Serbian government. So for now.
Thank you. Samo jedna molba za sve prisutne. Ako možete, slobodno se uključite, pitajte što god vas zanima, stavljajte svoje primedbe. Izvolite. Could you just wait a second for a mic? It's coming.
Now it is. I'm Professor Fernandes Yankov. I work in Brazil, Portugal, and I'm happy to work here in Serbia. I've been working in the field of mining law in São Paulo, and it was quite exciting, I must admit. But I would like to ask a question to the colleague Pari Vodic, if I'm pronouncing that correctly. I understand there was a concern regarding the mining right becoming a financial instrument. And I found it quite interesting the way you approach in terms of legal theory in mentioning the idea of usus fructus. But I would like to ask here in Serbia how the financial market is working in these terms, because our experience has showed us that the mining law was not enough. We had to change the financial market, the legislation that would allow us to issue an instrument. So the mining right would become a bill. And this bill would be subject to become a financial instrument. And then we could have a deposit account. So I would like if you could clarify a little bit how in Serbia this issue is being faced in terms of the financial market. Thank you.
Thank you. Thank you, Madam. Your question is a very advanced one for the state of Serbian mining law. It's very interesting. We still do not have, for example, securities backed by mortgages. We still don't have that. We don't have securitizations still in Serbia. The concept of a mining right as a civil right, a civil law right, belonging not to administrative law but to private law, is very unclear. It's very unclear. When I mentioned the relationship between the state as the owner and the mining company as an usus fructarius, I actually made an analogy with old French law. In France, one kind of usus fructus is mining. So definitely there are certain entitlements within the administrative permit which are of civil law nature to take away the substance, which is actually Usus fructus is without using the substance. That's the difference. And here you're exploiting the substance. I agree. I agree. Only looking at it from a very long perspective.
Absolutely.
I agree with you. Usus fructus is salva rerum substantia.
Yeah, we cannot use that for the financial market in terms of explaining the financial instrument that is based on this mining right. So this is why I'm asking specifically this question. How, in terms of legal theory, you think this could be supported in Serbia? Because without this, it is almost impossible to think about finance. Because what are the guarantees?
Well, I understand currently the administrative right granted by the state is transferable under the law, but that is very seldom used. Typically, the structure is based on the fact that the Serbian subsidiary owns the right, and then the parent company or the parent of the parent actually does the transaction somewhere on the British Virgin Islands and some typically exotic summer holiday place. So we didn't have, to my knowledge, transactions which directly implied changing of hands of the mining right.
But how do you see, is there any kind of limitation towards foreigners? Because, for example, some countries, they have this option. You can do it within nationals, but you cannot do it to foreign companies. And this was
We don't have that limitation.
Okay.
Foreign companies can do that. You have it, for example, in Kazakhstan, that irrespective of where the transaction is happening, if it reflects the use of Kazakh natural resources, it's prohibited by Kazakhstan law. This is not the case in Serbia. The Serbian law covers only the territory of Serbia, so transactions which are beyond Serbia are not controlled by Serbian law.
This was not my concern. Sorry if I'm taking too much time in this debate. I'm sorry if there's anyone that would like to ask, I would stop. But what we saw is that we can do the transfer within nationals, but if there is a foreign company operating in the country, this company cannot have the transfer of rights. Therefore, this company could not issue the instrument. So this is what I'm asking you. But if you're telling me that in Serbia you don't have the transfer, so then
no, we do have the transfer, but we don't have the instruments. What kind of instruments?
How do you transfer them? Because you are transferring the concession.
You transfer it by a contract, basically, with the permission of the state.
Right, but you don't have the instruments being issued still because you don't have the financial legislation that would accept it as a security.
We don't.
I understand. So there's room for us to think about it and to work on it.
Why not? Why not?
Thank you very much.
Could be fun.
Thank you. It was interesting, but it leads us to another question for Janko. Janko, so you're a practicing lawyer, as all of us are. What is the best practices you have with respect to the project finance? When you need to respond to the client, what is the options and what is the best practices? What is your first response?
I think we need to go back to the needs of mining companies. So some companies are large companies that do not need to generate funding externally or needed to generate it in a quite limited way. But one commonality of companies that do need quite a lot of funding and companies that do not is the fact that they require long-term security, long-term stability in order for potentially financiers to join in or to fund it entirely. And in that sense, International Bar Association in 2011, the top worldwide association of lawyers, has identified a number of best practices which I think can be transplanted across to Serbia, thinking about legal framework overall. Obviously, land rights, land acquisition, security of land rights long-term. Whether an exploration and exploitation license long-term will be stable administratively from point of administrative law, from any other point of law if we have investment agreements. So whether long-term stability of land rights is there. Secondly, duration. So we have possibility to extend exploration, exploitation licenses, but once we have discovery, once we have commitment of a company to invest and to fund it itself or seek external funding, we need to think about duration. So 25 to 30 years plus extension right is the industry standard in some developed jurisdictions. Infrastructure, well, quite practical and quite important. If we have remote areas that have significant reserves, let's say, lithium, copper, gold, we need to think about building access infrastructure. And we have numerous examples worldwide how that's approached. One possibility is to have the possibility of an investor funding access infrastructure with the right to set it off against future royalties or taxes that such companies to pay. So that's one possibility. Thinking about initial large investments that a company is committing, and the way to offset it is one of the best practices that we've seen worldwide. Taxation, I won't dwell into it too much, but it's important to say that in investment agreements, comprehensive investment agreements that we've seen worldwide, all taxes and tax-like payments are listed. So we comprehensively list all current and future levies, taxes, charges that will be imposed on investing company, and say, well, at this moment, at the time of signing, we have these obligations in terms of taxation. So being completely clear about what we are including in that contract that's to last long term. An important one are basically what happens if we have an adverse change in law. If the law changes after you've entered into an investment agreement, and the question becomes who needs to pay, who's liable, are there any obligations by the state or by the investor? So including stabilization clauses in those investment agreements is conducive to investment. So whoever's funding it, be it the company itself, if it's a large mining company, or a junior company or mid-sized company seeking external funding, they want long-term stability in terms of legal protection if we have adverse changes in law. Termination rights, basically the assurance that mining rights will not be unilaterally terminated by the state unless we have force majeure event or we have persistent or material breach by an investing company. So obviously termination for good cause only. And finally, in terms of international best practices that we could implement or heed advice from is basically the desirable dispute resolution either before ICSID or ICCC, so International Chamber of Commerce or International Dispute Resolution Body in Washington for the resolution of international investment disputes. So we can obviously take some advice from these best practices that IBA has developed, and obviously in this current legal framework tailor it to Serbian legal climate, if I can say that. So
it's not a storm.
It's not a storm. I mean, since 2015 things have stabilized. We've seen numerous companies present in Serbia. We've seen the fact that Serbian mining laws are topping the list of European mining laws, so there's not much to, so to speak, complain, but obviously there are certain things that can be fine-tuned in that sense. So,
it looks as we have a question again. Could you bring a mic to the lady?
Not working. This is really an interesting topic. You mentioned the International Center for Dispute Settlements regarding the investment agreements. And it is my curiosity, and I think it is very important to know how Serbia, especially in terms of the legal system and the legislation, is thinking about dealing with the most favorable clause in the contracts. Because this has been really a big issue when we have investment treaties and we have disputes under arbitration. The most favorable nation clause has really been an issue. How is this being faced here in Serbia within the community that is preparing the legislation and that should face this kind of challenges?
Well, thank you for the question. The issue of bilateral investment treaties.
The principle of most favorable nation, the favorable nation clause, when you have a treaty between two countries, especially in these investments, whenever you have a kind of policy towards one country or towards one company, this policy should be the same applicable to all of them within the country. And this has been an issue.
It depends how it is defined in the treaty.
No, but the principle is settled. This is a principle within the center. You cannot get out of this. Otherwise, you cannot get into the arbitration. So this is why I'm asking how you envision this, how this is being regulated in Serbia, if it is being regulated in Serbia.
Well, it is in Serbia. How it is regulated in Serbia?
How the principle has been regulated in Serbia.
But you have a law on foreign investments, and you have the bilateral investment treaties with each individual country. So it depends of the country of the origin of the investor. He's protected by his own bid.
Oh, all right then. That's okay. Thank you.
So this is the principle. So if you're asking how it looks in practice, then
look in terms of mining, because we are talking about the mining issues. And when you have a contract with a foreign company, these contracts are all subject, depending on how you're writing, but usually they are subject to arbitration. And the most favorable nation
I can tell you, madam,
is a very important clause.
Absolutely.
So
there is, but this clause is a second-tier clause. The first clause is the umbrella clause in the BIT. So if there is an umbrella clause, then the state has actually given prior assent to an ICSID arbitration. So the investor may just file a lawsuit before ICSID arbitration, and that shall be considered an assent in terms of the regulations of the ICSID arbitration. If that state does not have an umbrella clause, if the state of the investor does not have an umbrella clause in a BIT with Serbia, then there is a possibility of relying on the most favored nation clause.
Yes, this is the system.
Absolutely, and the most. So you can.
Serbia.